Okay. Hello everyone. I welcome you back to this course of legal reasoning, basic to advanced. This is our third lecture or the third video of the series. I am pretty sure that by this video, all of us are clear with the basic fundamental that the entire video series is based upon solving legal passages, understanding how questions are framed, understanding how we require no prior legal knowledge to solve these questions or ace these sections. In this third video of this series, we'll continue with the paper of 2020. We'll finish this paper in this video and then in the subsequent videos move ahead. So without wasting our time, let's move to the paragraph. The paragraph starts with stating that the principle of natural justice is derived from the word jus naturale of the Roman law, and it is closely related to common law and moral principles, but is not codified. It is a law of nature which is not derived from any statute or constitution. The principle of natural justice is adhered to by all the citizens of civilized state with supreme importance. Natural justice simply means to make a sensible and reasonable decision-making procedure on a particular issue. Sometimes it doesn't matter what is the reasonable decision, but in the end, what matters is the procedure and who all are engaged in taking the reasonable decision. It is not restricted within the concept of fairness. It has different colors and shades which vary from the text, which vary from the context. Basically, natural justice consists of three rules. From this particular paragraph, we have understood the fact that we are going to talk about the principles of natural justice. Then, we understood the fact that natural justice or the principle of jus naturale is not codified. Codified, if I mean to explain, is basically a law that has been written down into a constitution or any legal document that promotes or that provides the law validity. So jus naturale or the idea of natural justice is basically a principle of common law, is closely related to common law and is not codified. So basically is understood by everyone, is followed by everyone, but is not written down in the books of constitution. Fair? Then the paragraph talked about how this particular concept, this particular principle is followed by all the civil states or the people of these civil states. Not only this, but we were also taught that this entire concept of natural justice does not restrict itself to the concept of fairness, but rather it has different shades in terms, it has different rules, as we have been told in the later part of the paragraph. Moving ahead, let's see. The first one is the hearing rule, which states that the person or party who is affected by the decision made by the panel of expert members should be given a fair opportunity to express his point of view to defend himself. Fair? So, we are here talking about the hearing rule. Now, what is the hearing rule? So, whenever there is a panel of experts, okay, who or which is involved in decision making, the person who is being tried, the person who is being tried or the person who is being questioned must be given a fair chance to defend himself, or rather, in layman terms, everyone should be allowed to speak for their own cause. This is the first rule that we must keep in mind. Let's move ahead. Secondly, bias rule. Generally, expresses that panel of experts should be free from bias while taking the decision. The decision should be given in a free and fair manner which can fulfill the rule of natural justice. And thirdly, the reasoned decision, which states that order, decision, or judgment of the court given by the presiding authorities with a valid and reasonable ground. Fair. So now we have read two rules, one being the bias rule and the other one being the reasoned decision rule. So the bias rule generally expresses that the panel should be free from bias. If there is a bias while they are taking a decision, the decision will not be fair, will not be just. Rather, the decision that they will be taking will be considered unjust. Moving ahead, the third or the last rule that is a part of just natural is that reasoned decision. The order, decision, or judgment of the court given by the presiding authorities with a valid and reasonable ground. So the grounds on which the case is being adjudicated, the grounds on which the decisions are being given, they should be all reasonable grounds. The principles of natural justice have been adopted and followed by judiciary to protect public rights against arbitrary decisions by administrative authority. One can easily see that the rule of natural justice includes the concept of fairness. They stay alive and support to safeguard the fair dealings. The passage was fairly simple. They talked about the idea of natural justice and the three principles of natural justice. One is the hearing rule, the other is the biased rule or the bias rule, and the third one is the reasoned decision rule. Hearing rule basically states that everybody should be given an opportunity to speak for themselves. The bias rule states that all the individuals who are involved in the process of decision making should be free of biases. And then we have the reasoned decision rule, that every decision that is provided or that is given should be a decision that has reasonable grounds, that has reasons to support it, and proofs to substantiate it. Now, we'll move towards the questions of the same paragraph and see how we can solve them. Question number 15. Nemo judex in quasi soa, or the principle that no one can be a judge in his own case, relates to which of the following rule of natural justice? So looking at this particular maxim, the maxim states that no one can be a judge in his own case. So when you are a judge in your own case, when you are deciding for yourself, there is a high probability that you will decide in your own favor, because that is what a normal human being would do. There might be humans filled with wisdom who might give a just decision, but here we look at a reasonable person, a normal person. Now let's explore the options. Option A, the bias rule. Fair, because while we'll be deciding for ourselves, we'll be biased in a sense towards our own needs, our own interests. Coming to option B, reasoned decision rule. The decision might be biased, but still there can be a reasoned decision. There can be reasons of reaching at that particular decision. There can be reasons and proofs of substantiating that particular decision. So I don't think that reasoned decision rule is something that would be violated or will relate to this particular scenario. Hearing rule. When you are a judge in your own cause, you will obviously here the other individual, and here yourself too. So the only option that particularly relates to this entire set or this entire idea of nemo judice in causa sua, which is no one can be a judge in his own case, is the bias rule. Let's move ahead. Question number 16 states that Mr. X is a public servant employed in a public sector undertaking, and Miss Y, who is the wife of Mr. X, is also an employee of the same public sector undertaking. Miss A files a complaint against Mr. X for sexual harassment at workplace before the ICC, or the Internal Complaints Committee, which is headed by Miss Y. After completing her inquiry, she held that Mr. X is guilty and recommended disciplinary proceedings against him. Now, on what grounds Mr. X may challenge her findings? First of all, we need to take into account the very fact that when we talk about bias, there is a negative connotation associated with that term. Bias can be of any sort. It can be a negative bias or it can be a positive bias. We always relate bias with a positive connotation, stating that or thinking that an individual will only act in a positive manner, but rather the individual may act in negative manner too. Let's look at the options. Miss Y is an employee of the same institution, and the inquiry should have been conducted by a person outside the institution. Though the option would seem just and fair to a lot of readers, a lot of people who would attempt this question, but then again, does the passage talk about some externality? Does the passage talk about anyone, any sort of rule or any sort of clause that would require us to consult a person outside the institution? No. So option A is not the correct option. Then we come to option B. The complaint was filed by a female employee, so the inquiry must have been conducted by a male employee. The option is vague and has no substance to it. Let's move ahead to option C. Miss Y is the wife of Mr. X, and she holds a personal bias in the case, so the inquiry should not have been conducted by her. Which is a fair thing. It seems just, it seems fairly substantiated and reasoned. The option states that Miss Y is wife of Mr. X and she can hold a personal bias, be it a negative one or be it a positive one. So the inquiry should be conducted by someone else. Let's read the last option. Mr. X, being the accused, should have conducted the inquiry himself. Wouldn't that bring in the bias rule? Yes, that would. So we would choose option C as our right option and move ahead. Question number 17. Mr. A is a judge and he is also the landlord of Mr. B. Yes. So Mr. A is a judge and he is also the landlord of Mr. B, who resides in an apartment owned by Mr. A. Due to non-payment of rent for 3 consecutive months, Mr. A served an eviction notice to Mr. B. Now choose the most appropriate option amongst the following. So there are 2 individuals involved. One, Mr. A, who is a judge and also a landlord. Then we have Mr. B, who resides in his apartment. who resides in the apartment of Mr. A. Now, in this particular question, we need to decide what is the appropriate option because Mr. A has given a eviction notice to Mr. B. Eviction notice is a notice asking the resident of the particular place to empty the space and leave. Let's move ahead and look at the options. Being a judge himself, Mr. A cannot issue notice of eviction. No, why not? Because a notice of eviction is issued or can be issued by the owner of the house to any of the residents that live there on rent. He can or she can ask them to leave. Mr. A can issue such notice because it is his duty as a judge apart from being a landlord. No, this option B is on the same lines as that of option A and is wrong. Such notice is illegal as Mr. B was not given an opportunity to present his case. Option C might seem a tempting option, but then again, option C is not something that we would take into account because we have no knowledge of the same. Mr. A issued such notice in his personal capacity as a landlord and not being a judge. Fair. We would mark this option as the correct one and proceed ahead. Which of the following is not in violation of the principles of natural justice? Withholding of an increment of a public servant without giving him an opportunity to defend. Is it in violation of the idea of natural justice? What is happening here? They are withholding the increment of a public servant without giving him an opportunity to defend himself. An opportunity to defend himself will be counted under the idea of the hearing rule. So this is in violation. Non-renewal of contract of employment of an employee after the period of contract is over. So in this particular case, we would talk about non-renewal of the contracts of employment. But non-renewal of a contract that is relating to employment is basically related to the idea or the instance of discretion. It is related to the choice of somebody who is employing you, if he or she wants to keep you in that particular job or not. Option C, initiating a departmental inquiry against a public servant without giving him an opportunity to submit representation during such an inquiry. Fair. So then again, the hearing rule comes into question. The hearing rule comes into the idea as the entire inquiry has been conducted and the public servant has not been provided with ample amount of opportunities or hasn't been given a chance to represent himself. It is only option B which talks about renewal of contracts, and renewal of contracts cannot be counted as something that goes against the principles of natural justice. An employer can choose any individual he or she wants to have in their workspace. On the basis of your understanding about natural justice, state which of the following is true. Adherence to the reasoned decision rule is not required if the other two rules are complied with. Okay, let's consider a scenario where you have no bias where you have heard both the parties or the parties that are relevant to the suit or the case, but then there is no substance to your judgment. The judgment that has been pronounced or that has been delivered by you as a judge does not include a reason. And due to lack of reason, the judgment at certain points can be considered unjust. So, this is something that is not right. Let's move ahead. Compliance with the bias rule itself rejects the need of hearing and reasoned decision rule. You might not have a bias against somebody, but then again, there might be situations where you will need to hear the parties. You will need to take their perspectives, their ideas, their proofs into account. Not only this, but you will also have to understand that the decision needs to be one that is well reasoned. Principle of natural justice is incomplete without the compliance of any of its rules, which is the right thing to say, because one needs to be unbiased, one needs to entertain the ideas or perspectives of all the parties, and then again, one needs to also bring reason into his judgment. The reasoned decision rule is a substitute for the bias rule. No, we will not say this too. If the decision is well reasoned but is biased, which is possible, which is fairly possible, because you can have reasons for giving a biased judgment, but then again, that would create a judgment that is unjust, that is not performing justice. Option C is the right option, and now we'll move to the next paragraph. Tension prevailed in Jawahar area in Palghar district after three Mumbai residents travelling in a Ford EcoSport to Silvassa were allegedly lynched late on Thursday night. The Kasa police said the incident occurred near Gadakchinchle village under their jurisdiction. Information received by us indicates that three occupants of the SUV hailed from Kandivali in Mumbai and were going to attend a funeral in Silvassa. Superintendent of Police Gaurav Singh, Palghar Police said, so this was the statement of Gaurav Singh. A large mob of villagers surrounded the car within a matter of minutes and started attacking it with sticks, iron rods, and their bare hands, leading to the deaths of three occupants. One of our patrolling vehicles later spotted severely injured trio lying on the road and stopped to find out the matter. However, our team was also attacked by the mob and the vehicle pelted with stones. Our personnel had to flee and were unable to rescue the victims. An officer with the Kasa police said. A wireless alert was sent out later, apprising all police stations and units of the incident, following which reinforcements were sent to village and a combing operation was undertaken. Prima facie, information indicates that the trio were mistaken for thieves and attacked. The villagers were on edge due to ongoing lockdown and unavailability of essential supplies. For past few days, several rumors have been doing the rounds on social media about thieves and dacoits targeting villages on highway. As a result, villagers have been patrolling the highway and stopping late night travelers on suspicion, the officer said. This entire paragraph basically explains the idea of mob lynching, how, based upon a mere suspicion, the individuals that were lynched, that were driving Ford EcoSport, were lynched by bare hands, rods, stones. Even police could not rescue them or provide them relief. It was later on, when reinforcements were sent, only then could a combing operation be operated. This is basically how the mob lynching happened. Not only this, but the passage basically explains to us mob lynching. There is no specific law that we have talked about. Mob lynching as an activity has not been explained. Neither there has been any sort of uh, rule that has been given to us or a penalty that has been provided. So the questions will be general in their nature as we can expect. Now let's move ahead. Which of the following statements given below justifies criminalization of mob lynching? In a democracy, the actual power rests with the people and their actions cannot be penalized by the state. If actions of people cannot be penalized by the state, then grave actions like those of murder, rape, and any of the heinous actions of the humankind or the citizens of state would be given validity, which cannot be done. So A is a wrong option. There is no law in India which specifically prohibits mob lynching, and therefore it is a justified act of the people. Here we talk about justification in terms of morality rather than law. B might be an answer. Let's see. It is impossible to punish the wrongdoer in case of mob lynching. This does not align with what we have been asked. Violence cannot be a tool to implement the will of majority, and such actions are failure of the state. This is the right option as it aligns with what we were asked. We were asked that which of these options justify criminalization of mob lynching? Option D justifies the criminalization. Which of the following statements justifies the criminalization of mob lynching as a distinct offense apart from murder? The offense of murder is committed by a single individual or a group, but mob lynching involves a large group of individuals. Fair. When violence is committed by a mob, it creates a situation of terror and anarchy, having potential to disturb the public peace for a longer period. Fair. Mob lynching is an offense which supports the idea of might is right and cannot be accepted in a democratic society. We'll consider all of them right because we have been asked to justify criminalization of mob lynching, and we have been asked to differentiate such criminalization from the offense of murder. The above passage states about the existence of rumors in the area regarding the thieves and dacoits robbing the villages or committing child lifting. In the light of this proposition, which of the following statement is correct? Villagers should not be punished as there was a genuine mistake on their part. The option is self-contrary. The villagers should be punished as they do not have any right to punish any person unless he is an offender. So, if they were offenders, would we allow the villagers to punish them? We would not, because it is not the task of the villagers, it is not the task of the individuals to take law or enforcement of law or correction of such offenders into their own hands. The villagers should be punished as no individual in the country is entitled to take law in his own hands and punish the wrongdoer. Fair. The villagers should not be punished as they have right of private defense against such incident which they can even kill a person. Option D is vague because then again when we look at option D, there was no private defense that was taking part. There was no imminent threat, and neither we have been told or informed about how private defense works, so we'll stay away. In light of the above passage, which of the following incidents of mob violence would be justified? A group of people committing violence against people who are selling meat of an animal considered sacred under their religious beliefs? No, we will not consider it what we would say justified, because this particular group is harming the sanctity, is harming the entire, what we would like to say, constitutional structure of the country. So no. B states that the resident of a boys' hostel caught a drug peddler selling drugs in their hostel and, and killed him by beating. We cannot consider this particular option too, as the boy took law into his own hands, which is wrong. The villagers injured a woman by pelting stones on her, considering her to be a witch. So none of these. Let's move ahead. Assertion: mob lynching can be justified only in circumstances where religious sentiments or feelings of a large group of people are associated. No. Religious sentiments and feelings are of paramount consideration for the state and should not be interfered. No. So both A and R are incorrect. Sorry. Both A and R are incorrect, and this is pretty much self-explanatory at this point. Now we have been given something by Mr. Chandrachud. Fair. We have been given something by Mr. Chandrachud. Let's see. The bench of Dr. D.Y. Chandrachud and Mr. Shah J.J. has refused to transfer to CBI the criminal cases lodged against the Republic TV editor-in-chief Arnab Goswami for alleged defamatory news show telecasted on April 21 in connection with Palghar mob lynching case. It also quashed all FIRs against Arnab Goswami except one, which was filed in Nagpur and which has been transferred to Mumbai via order dated this. Now let's see what our Chief Justice of India, Mr. Chandrachud, has said regarding the same in the judgment. The Honorable Chief Justice has said that Article 32 of the Constitution constitutes recognition of the constitutional duty entrusted to this court to protect the fundamental rights of the citizens. The exercise of journalistic freedom lies at the core of speech and expression protected by Article 19(1)(a). The petitioner is a media journalist. The airing of views on television show which he hosts is in the exercise of fundamental right to speech and expression under 19(1)(a). So, in terms of law, we have understood the fact that Article 32 gives the courts the power or entrusts them with the duty to protect the fundamental rights. Then we have understood the fact that Article 19(1)(a) protects the freedom of speech. Let's move ahead. India's freedom will rest safe as long as journalists can speak truth to power without being chilled by a threat of reprisal. Free citizens cannot exist when the news media is chained to adhere to one position. Yuval Noah Harari has put it succinctly in his recent book titled 21 Lessons for 21st Century. Questions you cannot answer are usually far better than answers you cannot question. So this particular passage ends on a poetic note. The passage talks about Article 32, the fundamental right of speech, and how Journalism or reporting of what happens in the country is important for the democracy, is important for free citizens. With two basic laws, Article 32, which protects the rights of the citizens, and Article 19 with A, which protects the freedom of speech. Let's see how we'll solve the question. The above passage mentions about journalists' request to transfer the case of CBI for investigation. What could be the appropriate reason for such request? The journalist in the above passage has said that the government must transfer the case to Central Bureau of Investigation, and the question here is asking us what could be an appropriate reason. Let's see. The CBI is a central investigation agency and conducts more scientific investigation. This might seem the right option, but is not, because basically uh, this is not an argument that you would give to substantiate uh, your claim of getting the case transferred. Let's move ahead. Where state government is an interested party, the investigation conducted by the state police may be biased. Now, this is something that is having a reason to it, a valid reason to it. The option states that the state government, which also controls the police, is an interested party in this particular case. Fair? And if they conduct the investigation, then what would happen is that they would have their own biases, which they would use while conducting the investigation, which could jeopardize the entire activity. The FIRs relate to an offence of defamation of the president of a national party, so the matter should be investigated by the CBI. Again, a lame reason. Now, the only option that is well reasoned is option B. Let's move ahead. The above passage quotes the observation of the court in relation to freedom of speech and expression as questions you cannot answer are better than answers that you cannot question. Now, based upon such observation, choose the most appropriate option which describes the scope of such questions. The term questions mentioned are not subjected to limitations imposed upon the freedom of speech and expression. Why not? Everything in our country is restricted to the limitations that are imposed. You cannot go out and defame somebody or insult somebody. So there are these restrictions to the idea of free speech and expression. So we'll not go with option A. Those questions are limited to information warranted by the person. This option is vague. The court is referring to the right of information through the above quote. No, this is not the case here. Let's look at the last option. The questions are also subjected to limitations imposed upon the freedom of speech and expression. Fair. This is the right option. This is a reasonable option. Let's mark it correct and move ahead. Just a second. Fair. It is an established principle of law that the offense of defamation has many exceptions, and the imputation of truth is one of those. But the accused must prove that such imputation was true and also for public good. In light of the statement, which of the following questions and statements are not defamatory? An article published in a newspaper about the unaccounted property of a public servant in the form of a questionnaire. A questionnaire is basically a group of questions clubbed together, asked to you to extract information which can be later analyzed. So basically, the public servant was given a questionnaire which he filled up, and then which was further published in the newspaper. Fair. A question to a female actress about her sexual relationship with a married man. No, it is not of public good. A question to a public servant about his extramarital relationship with a colleague. Then again, not something that is of public good. An article published in a magazine stating a female politician as a B grade actress. Again, might have truth to it, but is not something that is public good. The only thing about public good is this option A. In the above passage, the court ordered for merging of different FIRs into one to be conducted at Mumbai. What is the reason? Multiple FIRs means multiple investigations and the same might cause hardship to the accused. Fair. The first FIR was registered at Mumbai. We don't know this. The accused resides at Mumbai and should be conducted in Mumbai only. No, not a fair reason. Multiple FIRs are frivolous and as there is only one cause of action. No. So option A is the most well-reasoned option. Defamation is punishable both as civil and criminal wrong. Fair. Only as civil, only as criminal. No. So this is something that you will gain from a general knowledge. The defamation can be punished both in terms of civil liability and criminal liability. Now, let's look at this passage of common intention and how common intention and similar intention work. After this passage, we have one passage on ex post facto laws, and then we'll be done with the paper of 2020. Let's pace up and finish this paper. Common intention implies a pre-arranged plan and acting in concert pursuant to the plan. Fair. So common intention is related to a pre-arranged plan. Common intention comes into being prior to the commission of the act, which need not be a long gap. Fair. To bring common intention into effect, a pre-concert is not necessarily to be proved, but it may well develop at spot between a number of persons and could be inferred from the circumstances of each case. So there is what the passage has said till now is that common intention implies a pre-arranged plan and acting in concert to that particular plan. Common intentions come into being prior to the commission of the act. Fair. Before you have committed an act, you have had a common intention, which need not be at a long gap. So just a minute or two before doing such an act, you had a common intention with somebody you were going to rob, your partner in robbery. That could be termed as common intention. To bring common intentions into effect, a pre-concert is not necessary to be proved, but it can be developed at the same spot and can be derived from the circumstances. Fair. Let's see the example. For example, A and B caught hold of C, where only B stabbed C with a knife, but A is also liable for murder as there was a pre-concert in this action. In Pandurang versus State of Hyderabad, Supreme Court emphasized on this point that prior concert need not be something always very much prior to the incident, but could be something that may develop on spot on the spur of the moment. Fair. So common intention can develop just on the spot while the action is taking place between individuals who are working in a group or in a team, be it for any illegal activity. Common intention and similar intention. Common intention does not mean similar intention of several peoples. To constitute common intention, it is necessary that intention of common intention, it is necessary that intention of each one of them to be known to rest one of them. In the case of Dukhmochan Pandey versus State of Bihar, the Supreme Court held that common intention which is developed at the spur of the moment is different from similar intention actuated a number of persons at the same time. The distinction between a common intention and a similar intention may be fine, but is nonetheless a real one, and if overlooked, may result in miscarriage of justice. The mere presence of accused together is not sufficient to hold that they shared a common intention to commit the offence. It is necessary that each one of the several persons be known to each other for common constituting common intention. Fair. So until and unless all the individuals involved in an activity are aware of all the acts that they are to be performed while the plan of robbery or the plan of murder is to be executed, only and only then, if all the individuals are informed, the idea of common intention can come into place. If not, then the additional activity can be called similar intention. A gang of 6 members went to a bank armed with weapons to commit a heist. While 5 of the gang members went inside the bank, Mr. A, the 6th member, waited outside the bank to alert them of any threat. During the heist, one of the gang members fired a gun at the branch manager. As a result, he died. All the 5 escaped, but Mr. A was caught and arrested. Now choose the most appropriate option as per the principles stated in the above passage. Mr. A is not liable for murder as he was outside. No, they had planned all of it. So, Mr. A with all the other members is liable for murder as there was a common intention. Raman and Raghav were riding a motorcycle on a busy street. Suddenly, Aman bumped into their bike. A heated argument started between the three of them. While Raghav started abusing Aman, Raman hit Aman with an iron rod lying on the road. As a consequence, he died. Now choose the correct option. Both Raman and Raghav are liable for murder as there was common intention. No, there was no common intention of murdering. Not both of them discussed it or not both of them thought about it. Raghav is not liable for murder as there was no common intention to kill Aman. Fair. No one is liable is again a vague option. Only Raghav is liable as he started abusing Aman is again an option that is not well substantiated. We'll take option B and move ahead. After reading the passage, which of the following is not correct in relation to the difference between common and similar intentions? Similar intention is developed prior to the commission of offense, but the common intention is developed only at the time of the commission of offense. Okay. Under common intention, each of the offender is equally liable, but under similar intention, each of the offender is differently liable. In order to determine the existence of similar or common intention, one must analyze the facts and circumstances of each case. Fair. The boundary between similar and common intention is very fine and it may sometimes overlap. No. Fair. Let's move ahead. The last two questions. Mr. X and Mr. Y entered into a house at a night to commit theft. While committing theft, Mr. Y committed sexual assault of a minor girl aged 11 years. Identify for which of the following Mr. X is liable. Was there a prior intention of committing a sexual assault? No. Was something involved or a pertinent part of the entire act? No. So, the individual that has performed or that has done the respective act will be liable for the same. Only theft, as Mr. X had different intentions from Mr. Y. he would not be liable for any offense. Only theft as there was a similar intention. Both theft and sexual assault, no. Only theft as there was similar intention. Now, if you people get confused, you can read the last part, which stated that the mere presence of accused together is not sufficient to hold that they held a common interest to commit the offense. ठीक है? So we cannot say that it was similar intention, rather it was common intention that was a part of this. So we'll take option C and we'll move ahead. Which of the following statement is correct in relation to difference between common and similar? The intention of accused and co-accused can be inferred from the fact of the circumstances. Fair. Under common intention, it is considered that all accused have jointly committed the offense themselves and are jointly liable. Fair. Each accused is liable for the offense he has actually committed in common intention. If the common intention cannot be proved. Fair. We'll go with option D as the right option. I guess this is the last paragraph or last passage, yeah. This passage talks about, let's see what, Article 20 Clause 1 of the Indian Constitution prohibits ex post facto laws. Now we are not aware of what is ex post facto laws, and we'll see what is ex post facto laws. The expression ex post facto laws means a law which imposes penalties or convictions on the acts already done and increase the penalty for such acts. So basically, let's consider that today drinking water from a friend's bottle is not a crime, it's not an offense. And today you drink water through his bottle. Now tomorrow government comes up with an offense stating that any individual who drinks water from his or her friend's bottle will be liable or will be considered a criminal under this and this law. Now talking about this particular instance, only after the law is passed you will be considered a criminal. Yesterday when you drank water through his bottle, it was not a crime, so government cannot take you or arrest you for the activity that you did yesterday. It was only today that when such an act was considered a criminal act. Fair. The expression ex post facto means a law which imposes penalties or convictions on already done activities or increases the penalty of such acts. In other words, ex post facto laws impose penalties retrospectively. For example, Dowry Prohibition Act 1961 came into force from 1961 20 May. A person guilty of accepting dowry is punishable under the Act after 20 May 1961, not before 20 May 1961, which we have just discussed. Ex post facto laws are of three kinds. One, a law which declares some act or omission as an offence for the first time after the completion of an act or offence. Fair. So something that was not a crime becomes a crime. B, a law which enhances the punishment or penalty for an offence subsequent to the commission of that offence. Means till yesterday the penalty regarding drinking water from a friend's bottle was spending a night in prison. But today the same penalty has been increased to spending a year. Okay? A law which prescribes a new and different procedure for prosecution of an offence to the commission of that offence. Basically the procedure that is to be followed subsequently when the offence has been committed, that is a different kind of, this is the third kind of ex post facto law. Clause 1 of Article 20 provides protection only in respect of the first two categories. Means if the penalty is increased, you will not be subjected to that increased penalty. And second, if something was not a crime, when you committed it, you won't be charged for it. Fair. Article sorry, Article 20 Clause 1 provides that no person shall be convicted of an offence except for the violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than which might have been inflicted under the law in force at the time of the commission of the offence. Fair. So this is basic language of Article 20 Clause 1. The first part of Clause 1 provides that no person shall be convicted for an offence or violation when such an offence or such an act was committed was not considered to be an offence. And the second part protects the person from a penalty greater than which was prescribed by law at the time of commission. The Parliament of India legislated the Sexual Harassment at Workplace Act in the year 2013, and simultaneously some new offences were also added to the IPC. Mr. A is an employee of an institution against whom departmental inquiry has been initiated for committing sexual harassment of a female colleague in 2002. Now choose the correct option. Since such inquiry is valid as per 20 clause 1, the constitution as the complaint was made after the act came into force. We are not concerned when the complaint was made. We are rather concerned with when the act was committed, which is before such law was made. After 20 clause 1 will not be applicable as matter does not relate to an offence. As the act was passed in year 2013, any inquiry under such act is invalid? No. Only inquiry may be conducted, but no penal action can be taken. Fair. So this is a well-reasoned option that provides us our answer. We'll take it and we'll move ahead. Article 20 clause 1 will not affect which of the following pieces or acts of legislature. Act of the legislature enhancing the term of imprisonment. Act of legislature enhancing the amount of fine. Act of legislature changing the punishment of death to life imprisonment. Act of legislature changing the nature of imprisonment from simple to rigorous. So wherever we are seeing an enhance or an increase, there obviously we'll consider that Article 20 clause 1 would protect you, but where there is a reduction, there Article 20 clause 1 will save you. Sorry. Mr. A is a student of law, aged 19. He is socially active and expresses his opinions on every social and political event of nation. In one of his blogs, he severely criticized the policy of government of changing names of cities. He also stated that government is biased towards a particular religion. The said blog was posted on 19th April 2020, and subsequently an amendment was made to the Indian Penal Code whereby hate speech was made a distinct offence and punishment was prescribed. An action was brought against him and the said provision for the blog. Now choose the most appropriate option among the following. A may be liable for offence of hate speech as the blog was not removed. Fair, intelligent option. Mr. A may be liable for the offence of hate speech as Article 20 clause 1 does not cover such areas. Mr. A may not be liable for offence because the act was done before the amendment. Acts like publishing a blog constitute or are considered as continuous acts. So after such a policy was released, it was his duty to remove or take away or take down the blog, which was not done by him. Mr. A may not be liable as it was innocent and fair. So A is the right option. Considering the fact situation given in above questions, Parliament passes a legislation in September 2020, whereby an amendment is made to Juvenile Act and now a person below 20 would be a juvenile and special procedure would be followed for his trial. Choose most appropriate option. Mr. A would not be considered as it was prohibited under the scheme of 20 clause 1. No, procedural changes that provide benefit are not prohibited. Would not be considered, would be considered will be the right option. The last question of this paragraph. Considering the fact situation in third question to this passage, the Parliament passes a legislation for prohibition of offenders under which any offender below the age of 21 will not serve the sentence of imprisonment in a prison. Instead, he will serve the sentence in a prohibition house. Now choose the most appropriate option. It is the discretion of Mr. A, as option C says no. A will not get the benefit of probation offender as it is prohibited. No. It is leniency. It is related to how the process is being conducted. So he will get the benefit of the procedure. With this, we have finished the paper of 2020. The questions do not require prior knowledge of law, but rather a simple understanding of law. I guess by now the principle that you do not require a prior knowledge of law is well settled into the minds of all the individuals who have been through the series. We'll continue the series later and solve questions of the papers ahead. Thank you for watching. My name is Kanish. You are watching Legal Reasoning Basic to Advanced, and this is King's Academy. Thank you. Ah.